Good morning. Carol Wooten is with us today. Hi, Carol.
Good morning. Good morning.
She's been with us before. You know, Law Power Hour always likes to bring back people who've got subject matters and information and talent, especially talent, to share with our audience. I want to thank you all for your telephone calls I've been getting. I've been pretty punctual about returning your calls that I've received on the air, and I know Carol is also like that. Little story about Carol is that she's a solo practitioner. She does a lot of corporate work. She does a lot of probate work, and she's real diligent and responsible. One day I called her, an emergency situation. These folks needed a power of attorney. Carol was on the spot. Within 24 hours, she had all their probate matters lined up. I want to thank you for that.
You're very welcome, and thank you.
Well, I want you to know when I refer someone to Carol, I'm referring to them. There's nothing that I'm looking for by way of financial return. I'm only looking for one thing. It's a good result. People called me. They were satisfied that you did what you were out to do. You took care of them, and that's why you're here today. So we're on probate day, and we're going to have a probate day,
Yes.
aren't we?
Yes, very excited about that.
Yeah, on November the 17th, we're going to have a probate day. Now, why did I pick November the 17th, and why did I coax Carol into picking November the 17th? Well, on the following Thursday, it's Thanksgiving. And can you think of a better time to have a probate discussion with your relatives than sitting around the table being thankful that you're all there?
Yes, excellent, excellent idea.
Because it gives you an opportunity to probate plan, not divide up property without fighting. You know, on Thursday, a lady had me involved in litigation on a probate case, and I had to give her a refund because I told her she shouldn't be starting a lawsuit against the other heirs because she's going to waste money. There are 12 heirs, including this woman, and a substantial estate. She wanted an accounting. And I said to her, look, let them finish their inventory, let them finish their appraisal of all the property, and then you can see all the books and records. She was emphatic. She wanted it today. She said somebody was stealing. She had no proof of it. It's just a belief that she had. Well, you know, courts don't operate on beliefs, do they?
Not at all.
Okay, so the reason I said that courts don't operate on beliefs is because if Carol and I are having Thanksgiving dinner together, and she says, Barry, when something happens to me, I want you to take my house, ain't gonna work. It's got to be in writing. It's got to be signed. It's got to be notarized. It's got to be on record. And there's a right way and a wrong way of doing it. So on November 17th, we're going to have a program. And you're all invited. It's going to be at the Considine Center. I'm going to have the address published and on the screen next week from 12 to 4. It's going to be probate day. You can come down and get all of your probate questions answered. And these are the topics that we're going to talk about. We're going to go through them today. One of them has to do with a deed called the Ladybird deed. What's a Ladybird deed, Carol?
A ladybird deed, in essence, is putting a beneficiary on your home. And in doing so, the person, the grantor, would own the home as long as they live, so they'll have a life estate in the home. But by putting the beneficiary on the deed, they get filed with a county register of deeds. As soon as it's done, it allows a beneficiary to go on the property so it will not go into probate.
There's another important reason for doing it. Financially, if you have to go into a nursing home and you're on Medicare or Medicaid and you die and you don't have a Ladybird deed and you're the sole owner of your house, can Medicare and Medicaid come after your property?
If you don't have a beneficiary on it, yes, they can.
So they can come at, and even if you transfer it within 24 hours of your death, they can still come after it, can't
Yes, because Medicaid, they have a 5-year look back, which means if 5 years, if you try to do it and without, within that time frame, they're going to think that you were purposely trying to get it out of your name. So they look back 5 years.
they? And don't think for a minute when you're 4 years out that you can't get a letter from Medicaid asking you what you did.
That's absolutely right.
Okay, I want to tell you a story about that. We're going to use this as our test today. I have a friend who's 78 years old, and I'm not talking out of school, who lives by himself. He has a daughter. He He has a mortgage on his house. He lives on his monthly income from his pension. A lot of you better listen closely to this because it applies to a lot of you, and his Social Security. So he has some equity in his house. In other words, he has a value in his house in addition to the mortgage. House is worth about $300,000. He owes $210,000. So he's got about $80,000 value in the house. So he has stage 4 cancer. He was just diagnosed 6 months ago. And he's taking medicine. Thank God he's in remission. So his daughter said, "You don't have to worry, Daddy. We can transfer the property now. And there won't be a problem if you have to go into a nursing home on Medicaid." I told her that I wouldn't be a party to that because you can't do that. Is that true?
That's true.
Why can't you do it?
You can't hide property or transfer for the purpose of reducing the amount of assets that you have. And I wouldn't be a part of that either.
No, because you have to disclose what you own.
That's absolutely right.
And if you use a ladybird deed, it's still in your name, isn't it?
It's still in the person's name, correct? Life estate.
So by having a life estate, now this is very important to explain, that means my friend's daughter who has a bad credit record, her creditors can't get at that property, can they?
Exactly. Some people do a regular quitclaim deed, and that's not always wise because it puts the property in that person's name right away.
So if you come down to our program, you can learn the difference between a ladybird trust and a quitclaim deed and when it's appropriate to have one or the other. That's just one of the issues. The second issue is a durable medical power of attorney. That's a huge term. Everybody walking the street, listen up on this because it's really important. There isn't a soul walking the street who doesn't need a durable medical power of attorney. Is that a fact?
That is absolutely a fact. Very important document to have in place.
Now, tell our listeners why it's important to have these documents in place.
A medical power of attorney is essential because it takes care of someone speaking on your behalf if something happens to you. And being prepared is crucial because, and getting it done is crucial because you don't know when you're going to have an accident, or you don't know when, a medical need is places you in the hospital. So you get the document done now, you let somebody know where it is, and they can answer questions and speak to your doctor, make the decisions that you want to have made if you're unable to do so. Waiting until something happens may be too late.
When you go to the hospital, if you don't have a medical power of attorney, they get you to fill out a form and designate a person to speak on your behalf. Usually it's your spouse if you're married. However, maybe you don't want your spouse to speak on your behalf. Maybe you want your daughter or your son from your first marriage instead of your spouse from your second marriage. I'm looking at this from a practical point of view. I'm not trying to create any problems for families, but I'm looking at it from a practical point of view. So if you sit down at Thanksgiving and you talk about a durable power of attorney, you talk about if something happens to me and I have a stroke, this is a big issue in my practice. There isn't a week that goes by that I don't get a telephone call. Somebody's had a stroke. Can I get a power of attorney when they've had a stroke? And I tell them, no, we can't get a power of attorney when they've had a stroke because they have to prove that they're cognitive. They understand what they're doing. They have the ability to write their name. You can't come in and say, well, Mom could do that if she couldn't do it. And you can't come in and say, all the power is given to me if there's 3 or 4 siblings. You have to work through this together, and you can't wait until the last minute to do it, can you?
Right, and there are 2 issues with that. One is there's a problem when a daughter or a son calls and says, my mother needs a power of attorney. Because I can't take instruction from anyone except the person who needs the power of attorney. I can't meet with you because your mother needs a power of attorney. I have to sit down and meet with your mother. And as Attorney Keller said, I have to determine whether or not she's cognitive enough and lucid to tell me what she wants and why she needs it. And that's an issue if she can't do that. And that's what I mean by waiting too late.
I'll make it real simple. You can't bring your mother or your father in stooped over in a wheelchair and expect to have any attorney enter into a power of attorney. Now, it sounds kind of silly to say that, but you're out there listening, and all these probate problems occur, and all you have to do is come to our program on the 17th and you get all of them answered. For example, you and I are married, we get divorced. You have insurance, I'm named on your insurance, and you never take me off as a beneficiary. What's wrong with that?
There are many things wrong with it because you could get remarried and something happens to you and your current wife. One is not your beneficiary, and two, your ex-wife